Well, hello. I just want to give you some tips on that Chapter 51 case. I did put in the assignment that it has two issues and two holdings, and that they're based on the headings. But let me give you a little bit more. So, history. Remember, it starts with who sued who. And I'm talking about the Johnson versus Fluor case, the week 6 case that we're working on. And that is Johnson versus Fluor in Chapter 51. Okay, so the week 6 case I mentioned has two issues and two holdings, and they correspond, of course, with the questions, and they are based on the two headings in the case. Okay, so before we get to issue and holding, there's a section that was assigned called history, and history starts with who sued who. And in this case, this is one of the only cases I think that you will see this semester that does not have a jury or a trial court making a decision. It's actually the non-italicized part is the decision of the trial court. Okay, so it will not have who appealed. It will not have what the court decided below, because there's no below court. Okay, so you can find history in the last paragraph of the case. All right, so you can skip about filing a charge of discrimination with the EEOC. We're going to start with the lawsuit. Okay, for history we start with the lawsuit. So if you go halfway through that sentence, it starts and it'll say Johnson filed suit against FMS under Title VII, etc. Where that starts to the very end is what would go in history. So that includes what the causes of action were that she sued for, and FMS filed a motion for summary judgment in part on the basis that the undisputed facts established that FMS was entitled to immunity under the Farrager-Ellerth affirmative defense. And that's where you're going to end your history, is about the affirmative defense. This is the court now who's going to decide, does that affirmative defense apply to allow them to grant the motion for summary judgment and dismiss the case, or does it not? Okay, and then they give you two headings where they address two aspects of this affirmative defense. For the affirmative defense to apply, you have to have, the employer has to have protective measures in place and take prompt corrective action to address any sexual harassment complaints. And so they have a heading, and this is a heading, but we're going to have to change it into a question. This is worded as a heading, which is why every word is capitalized. When you turn it into a question, you have to take out that, okay, and make it, because we don't capitalize every single word, right? We make it just like a sentence. So I'm going to take this heading A, subheading A, and I'm going to change it into a question, and watch how I do that. Sorry, I got a little fly that wants to buzz around here, a mosquito. Yep. Gee, many crickets. It won't leave me alone. So, whether FMS took reasonable care to prevent and correct promptly any sexually harassing behavior. Okay, so I added the word whether, and I had to take out that apostrophe S after FMS, and I had to add the word took. So whether FMS took reasonable care to prevent and correct promptly any sexually harassing behavior, question mark. That's how you do your first issue for that case. And then if you read through it, you will see that they look at a prior complaint she made and how the FMS promptly had corrective measures in place and promptly investigated it and fired the person. Okay, so and that in your holding, you're going to answer that question, and they will tell you, don't use the last sentence. Don't give me something like the court finds that Johnson failed to show a genuine issue of material fact. That doesn't tell me anything about the factual basis for why they ruled that an answer to this question. Okay, so you want to say something more like FMS took reasonable care to prevent and correct promptly any sexually harassing behavior as demonstrated by their response to prior complaints where they promptly investigated and terminated an employee who had sexually harassed or who engaged in sexually harassing behavior, period. I took a little bit of the facts and combined it with a little bit of the law to make a full statement. So now we understand that they actually have corrective measures in place and investigated and then terminated somebody. That tells us something. The other one just says, no, failing to show a genuine issue of material fact can apply to any case of any nature that has a motion for summary judgment. So that's more of what I consider a procedural aspect about it, or the burden of proof aspect of it. That doesn't tell us anything. That's something that applies to every case, where summary judgment is filed. Sorry, I'm a little congested today. I think it's allergies. So now moving to issue number 2, which I said is the second heading. And guess what? This one, the only thing you need to do is take away all the initial caps except for the word like Johnson and the name FMS. Otherwise, it's already worded as a question. It's fine the way it is, but you have to take out the original, each word being capitalized, because that's not how we write a question. And so that one's fine. Did Johnson unreasonably fail to take advantage of any preventative or corrective opportunities provided by FMS or to avoid harm otherwise? So that's your second issue. It's worded already for you. You just have to make it grammatically correct by taking out those capitalized words. The holding, they look again at this, what's required for this affirmative defense. And one of the things that's required is when an employer has corrective measures in place, you have to promptly report it so that they can do their investigation while memories are fresh and witnesses are still there. You will find that in this case, Johnson took 17 months to report it. Now, she was familiar with the procedures that they had in place. She'd previously complained about behavior, so it wasn't like she didn't know, and yet she waited 17 months. So the problem is she has deprived the employer of the ability to investigate. People might not even work there anymore. So this is why this affirmative defense is available to a defendant if the plaintiff, which is here Johnson, failed to take advantage of their corrective measures in a timely manner. So we know what the issue is, and I'm giving you an idea of what the holding is because she waited 17 months and they said that was not okay. So now the results section is usually the easiest, and it's usually in bold font at the end of the case. It can be words like affirmed, reversed, reversed and remanded, whatever it is that the court did with the case once they make their decision. Here they made the decision the affirmative defense applies, that FMS is entitled to a dismissal of the case, granting the motion for summary judgment and dismissing the case. So the result, bold font, end of the case. That's my clue to you. It can be one word, and that would be sufficient. Okay, so I hope that helps. And I hope you learned a little bit more about employment law.